Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Welcome back for another episode of Legal Tea. Today's topic is a current trend, something going on in the current time that is pertinent to my little estate and elder law world. Today's topic is about a decision that recently came down from the Indiana Supreme Court that, to be honest, I was a little surprised to hear the outcome. But I also understand the court's logic and explanation too. The case is Rotert v. Stiles, and it was argued on June 2nd, 2021, and the decision was just released on October 8th, 2021. Enough of this legal jargon. Let's talk about the juice. So what is this case about, you ask? So in 2009, Marcel Borcherding, I hope I pronounced that last name right, Borcherding, created a revocable living trust, leaving her estate at her passing to her son, Roger Rotert, daughter, Connie Stiles, and 4 stepchildren. The trust contained both monetary assets like cash accounts, investment accounts, and hard assets like property. In the trust, Marcel created a very specific provision for her son, Roger, which stated, quote, "In the event that Roger Rotert is unmarried at the time of my death, I give, devise, and bequeath his share of my estate to him outright, and the provisions of this trust shall have no effect. However, in the event that he is married at the time of my death, this trust shall become effective as set out below." End quote. You see, according to the facts of this case, Roger was on his 3rd wife. And no judgment here, just saying he was on number 3. The third wife's name was Donna, and Roger and Donna had been married for about 8 years or so. Shortly before Marcel created the trust, Donna actually had filed for divorce. Though sometime later, Roger and Donna reconnected, and they were actually married at the time of Marcel's passing. Side note, it's not super clear whether the divorce filing just never got finalized or if they indeed remarried. Nonetheless, they were married at the time of Roger's mom's passing. So in my personal and professional opinion, Marcel likely incorporated this specific provision in her trust for Roger just due to his marital history and wanting to keep Roger's inheritance protected. The manager of Roger's trust, or formerly called a trustee, of the trust for Roger was his sister Connie. After their mother's passing, Roger and Connie disagreed as to whether Roger's share should go into this subtrust for Roger. Of course, Connie likely wanting to follow the rules, and Roger, he didn't. And he just wanted his inheritance outright, and just free of trust. Connie attempted to appease Roger and distributed the subtrust cash outright to Roger, but kept the hard assets like the property inside Roger's trust. So that is what this case is about. Roger ended up suing and alleging that the provision in his mother's trust is what's called a void restraint against marriage. When I first read the synopsis version of this Supreme Court decision, my head immediately went to restraint on marriage. I remembered that during my law school days and bar exam studying, restraints on marriage are sort of frowned upon and not really allowed in my estate planning world. So I don't want to spoil the ending on what the court decided and how they made their decision, so I just won't go into any more of that right now. At the trial court level, Roger lost, and Connie, as representative for the trust, won. Roger appealed, and the Court of Appeals actually flip-flopped the decision, meaning that they found in Roger's favor, and Connie and the trust lost. The Court of Appeals claimed the trust provision is, quote, an impermissible restraint against marriage. Connie appealed the Court of Appeals' decision. She appealed to the Supreme Court, which is the decision I'm talking about today. And of course, that means that the Supreme Court decided to take the case. And they don't have to hear all cases, right? That's what I mean by that. So they agreed to take this case on and hear it. Anyway, so the Supreme Court heard the case, and in a multi-page opinion, the court actually decided in favor of Connie and the trust. So Roger lost. Their reasoning for the decision primarily centered around that restraints against marriage, the prohibitions of such, only apply to dispositions of assets, to a spouse, and by a last will and testament, and that the prohibition does not extend to a living trust like a revocable living trust, which is what Marseille had created. So here with Roger was Marseille's son, not a spouse, and the disposition was made by a trust and not through a will. So by a strict reading of the statutes, the restraint against marriage prohibition just does not apply here. And for clarification, and for anyone that has little to no experience with estate planning, in general, wills and trusts are two very different creatures. And while I won't go into details to how they are different, they are indeed so different that there are two different parts of the Indiana Code that deal with them. One for wills under the probate code, and one for trusts under the trust code. So what the Supreme Court basically said was that the whole restraint on marriage thing is something in the probate code for wills, but it's not in the trust code for trusts. For that reason, they did not extend the prohibition of restraint on marriage to Marseille's trust because the trust code does not expressly disallow it. The court further explained that yes, the Indiana Trust Code does not prohibit restraints on marriage, but what it does prohibit is, quote, ignoring the settlor's intent. Here, Marseille was the settlor, and her intent, to me, was pretty darn clear. And it sounds like the Supreme Court thought so too. They actually state in their opinion for this case, quote, given this mandate's a strong word, given this mandate to honor Borkading's intent, that's Marseille, her intent, we decline to invalidate the challenge provision by Roger or to restrict what the legislator does not forbid. Interestingly, Justice Goff, who wrote a separate opinion on this case, but ultimately agreed with the result, he shared that he was concerned that the outcome of this case would lead to a, quote, Pandora's box of unintended and harmful consequences, such as, quote, someone creating a trust with conditions such as the recipient not marrying a person from a different race, refusing to pay property taxes, or participating in another illegal act, end quote. I thought Justice Goff's opinion poses an interesting issue. And like I've talked about before on Legal Tea, where does the line get drawn? I'm not saying I agree, disagree, whatever. I'm just saying I appreciate Justice Goff's piece of wisdom here. He said in his opinion, quote, surely the legislator would not have intended such an unjust or absurd result, end quote. In Justice Slaughter's written opinion, he explained that the trust code references one time about, quote, public policy. And that's what the issue is here. The statutory prohibition against restraint on marriage is claimed to be against public policy. So Justice Slaughter references, he says there's one section that claims, XYZ is against public policy, and that is section 30-4-2-12, which you probably don't even care to know that, which states that, quote, terms of the trust may not require the trustee to commit a criminal or tortious act or an act which is contrary to public policy. Which obviously that makes sense, right? You can't write in a trust to require your trustee go rob a bank to add more money to your trust. So yeah, this case was an interesting one, at least for me, but I hope for you as well. As we sit right now, thanks to this Supreme Court decision, you can include fairly restrictive language in a trust if you don't super love your in-law or whoever your beneficiary is married to. But because this decision, right now it's only allowed in a trust, not a will. It's possible that this decision shines a big light on the Indiana Trust Code, and maybe legislatively they modify the trust code to prohibit this restraint on marriage, Who knows? Nonetheless, it is allowed right now for all of you that want to put restrictions on people inheriting based on their marital status. I'm curious to how this may work alongside a no contest clause. You see, a few years back, Indiana was the second to last state to finally allow for no contest clauses in estate planning instruments. So where my head goes is, what if you did have a desire to restrict a beneficiary's inheritance based on, for example, their marital status, and you include a no contest clause in your trust? If the trust code stays as is and allows for restraints on marriage, having a no contest clause would encourage the beneficiary from, not filing a lawsuit like Roger did. And if the trust code does get modified ever to prohibit it, would the no contest clause being in the trust document kind of deter beneficiaries from kicking up a fuss and filing a suit? It's interesting stuff here, huh? And they say my little estate and elder law world is boring, please. And you know what this topic reminds me of, though, and maybe it's just the way my weird brain works. But what Marcille did in her trust on its face is a custom estate plan. And to be honest, I like seeing the thought that Marcille put in her estate planning. So often, I see people just put together an estate plan without much thought. They don't really consider things like age. Do you really want someone like 18 years old inheriting without restrictions? Or lifestyle choices. Do you really want someone who is terrible with money inheriting outright? Or addictions. Do you really want someone who battles an addiction to walk into an inheritance without some oversight? There are ways to do your estate plan in a way to give to who you want, but do it in a way that is smart. It requires thought on your part, and it requires a qualified estate planning attorney to walk you through the how, but that's what we're here for. And it's really to help get your wishes, whatever those wishes are, on paper. I love to see that Marcille's wish and how specifically the wish on how Roger inherited stood up in a court of law. But at the same time, I take Justice Goff's point that this Supreme Court decision could be stretched and allow for people to take advantage of the flexibility that our trust code currently offers. But that's what the court is there for, to hear cases, to make decisions, and ultimately those decisions can provide parameters for us in the future. So when it is time to #do your estate plan, remember that it is your estate plan, that you're in the driver's seat, and you can pick and customize what you want to have happen. And if there are legal restrictions, like not being able to put a restraint on marriage through a will, the attorney, so long as they're qualified, will be able to explain what's allowed and what's not. I often tell my clients, you figure out what you want to have happen, and it's my job to make it legal and get it in writing. So next week's topic is we're back to estate planning of the rich and famous. And on that episode, we're going to be talking about Philip Seymour Hoffman, a great actor, great actor. So yeah, we will talk about him and his estate next Tuesday, Legal Tea listeners. Talk to you then and be well.